Nestled in a classic New England setting amid 200-year-old elm trees and charming colonial homes, stately sea captains' homes, and charming Cape Cod salt boxes, Shoreway Acres is a graceful blend of Cape Cod's past and present. Shoreway Acres, proud sponsor of Falmouth Community Television.
Welcome to Falmouth. If you're a visitor, this is where surf and sun meet for fun. If you're a resident, this is where you'll find the businesses and the resources necessary to fill all of your needs. If you're a business person, this can be your home. Join with other men and women who work together to make this a sustainable economy year-round. Welcome to Falmouth, Cape Cod.
The board has just returned from executive session. Again, this is the meeting of Monday, May the 11th. If you'll all please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we get going this evening, I'd just like to wish all of those folks who have any Irish heritage a wonderful, happy St. Patrick's Day week. As we will not be meeting between now and then, and I wanted to wish them all the top of the morning and hope that the Irish luck follows them wherever they may be. First up this evening will be a wetlands hearing with James and Nancy Wyatt for the applicant. Good evening.
Hi, good evening. I'm Jeff Ryther, representing the Wyatt family. This is down on Charles River Road. Let me get the number for you. I'm sorry, 23 Charles River Road, East Falmouth. It's on the Charles River. To get you orientated, it's the Edwards Boatyard, or former Edwards, is just up from this. This is across from the town landing. This is an existing house with an existing small unlicensed dock that the Wyatts just purchased, and they're going to remove the existing unlicensed dock, and we have proposed a pier ramp and float. Now, this has been through the Conservation Commission, so it's had, plenty of eyes looking at it so far, such as the Shellfish Warden, Natural Resources, the Harbor Masters look at it, Conservation has looked at it, and issued an order. And I have an order if you would like for your file, if you haven't gotten one.
I believe we do have an order of conditions.
Yeah, it's in here.
So just to go over the dock again, it's your basic 4-foot wide pier. Again, in profile, you'll see a ramp down to a float. There's plenty of water in this this site, so it's kept somewhat short. And you'll see that beyond the dock, there's a mooring. That particular mooring is going to be moved down to this one here. This was approved again by the harbor master. This current mooring is going to be relinquished by the owner, and the Swain mooring will move down to number 14. I think I got that number correct. I do have a letter for that started that whole thing. It says, well, I need my glasses for this. Hold on. This is from Patricia Walsh, who's currently using 14. I'm writing to inform you that I'm giving up my mooring CR 14 on the Charles River Road in Waquait. It's my understanding, and I agree, that the mooring owned by Stephen Swain, CR 12, up here, will be moved to my current location. Please let me know if there's something else required for me to relinquish this mooring space officially. And that was written to the harbor master. So again, before we started this, we had to, make some room. And the Swains owned this house and sold it to the Wyatts. And again, we had this mooring that was out front there that the Swains used, and they've found this space down here. So it opens up the area here for the dock. So it took a little while to work all the logistics out, but here it is. So any questions?
Just a couple of things before I open it to questions. From Chuck Martinson in the Department of Natural Resources. Have no comments at this time. From the Harbor Master's Office, no adverse issues observed at the time of inspection. Mooring issues, yes, resolved. See the comments similar to the docks in the immediate area. Mooring CR 12 Swain to be relocated to CR 14's location by agreement and approved as proposed. So I just wanted to read those into the record.
That's great.
Okay, any questions from the board?
Just a
Pat?
question. The mooring, EBYS, that remains?
I believe it
That's the one
does.
further up.
Yeah,
on the map.
yeah, that one will.
Does that
That's,
belong to the,
that's Edwards Boatyard. It's now, I'm
It's-
sorry.
it's not related to the property owner?
Oh, no.
Oh, okay.
It's Bosun's Marine, I'm sorry. It just slipped my mind.
Well, oh, that's right, that's a
Which
new
ones? Okay.
owner,
They bought Edwards.
Boston Marine.
And Doug?
I noticed in the earlier existing dock is unlicensed, there was a bunch of landscaping that had been done there that's being ordered to be removed per the order conditions. Is there going to be landscaping done at the, I couldn't quite tell on the plan, what's going to happen on the land side part of the new dock?
No, it's just, it just dies out into this lawn area, this area here that's, excuse me, this area that's shown in green on my plan, it'll
Yep.
say edge of lawn. So the dock just sort of dies into the lawn. If you see the profile, it's just one step up, and then it ramps up over the salt marsh, so it's not shading the marsh, and then back down to a reasonable elevation, and then the ramp and float off of
So
it.
it's just going down to the grass?
Yeah.
Okay.
Any other questions, comments from the board? Any public comment before we move forward? Hearing none, I'd consider entertaining a motion from the board. I believe that's the final plan.
Mr. Chairman, I move that we approve the applicant's plan dated December 18, 2012.
Do I have a second?
Second.
Motion and a second. Further discussion from the board? With none heard and no public comment, call for the vote. All those in favor? Aye. Aye, opposed? Ayes have it.
Great, great. Thank you very much, folks.
And we'll sign this plan if it's all right with the board. And then next up this evening would be a wetlands hearing, Toby Lane Association, Inc., Parcel 3A, Knockabout Trail, East Falmouth. For the applicant, Mr. Borselli, how are you this evening?
Chairman, good evening, members of the board.
I have extra copies of the plan.
Yeah, you have one?
I have one right here.
I can share yours.
I represent the Toby Lane Association. I'm joined tonight by a dock subcommittee chaired by Don App. Also on the committee is John White, Steve Davino, and John Fryer. I'm also joined tonight by Brian Wall, an attorney for the association. We're here tonight asking permission for the ability to rebuild an existing association dock effectively in the same footprint with some minor improvements. We have previously been before the Falmouth Conservation Commission for this project, and we obtained an approval and through an order of conditions issued by the Conservation Commission. The current association dock consists of a small fixed portion that is supported by posts in the salt marsh area, and from that fixed section, you transition to a ramp and a series of floats. In this case, there's four 6-foot wide by 10-foot 4-inch floats. They're in a state of disrepair and in need of replacement. And the association hopes to replace those with new modern float system with better materials, better buoyancy, better structural materials. The overall footprint of the floats today is 247 square feet. The overall footprint of new floats is 256 square feet. It's 9 square feet bigger, and basically although it's a minor increase in overall square footage, this dock is much more efficient in use by an association for what they use it for. What they use it for is to tie small craft. Most, I believe, are under 18 or 20 feet in length. They're small skiffs. Some people have a larger boat that's on a mooring. These would either be just recreational boats, or they may even just be boats that are used for recreation, but also allow them to get to their moored boat, which they would then take out. The current situation doesn't lend itself very efficiently to loading and unloading of people or supplies that you may need on a boat, because it's a straight section with the boat's being tied bow to the side of the float and stern tied off to a metal pipe that's driven into the area at the sterns of the boats. There's no there's no loading and unloading point on this system as it's currently been utilized. It's been utilized for decades in this position, by the way. The new float system will have a T at the end that measures 6 foot wide by 16, and that end section is used for loading, unloading of guests and supplies, and coming in to pick people up. It's not a permanent place to tie a boat. So what the association hopes to do is build this improved structure, install new tie-off pipes as well. There's no anticipation for any increased usage by more boats, just better, more efficient use. We're also proposing to rebuild the section that is in the upland, the fixed pier section, so that everything that is in the ground now or seasonally removed and reinstalled each year will be brand new. During our design and development of the plans, we had actually applied to you folks for a special permit several months ago. There are several continuances because of some issues within a abutter. We were trying to resolve some matters regarding a property line issue with the abutter. We ultimately withdrew the application instead of continuing to continue, and then we reapplied. And we reapplied in a way that, regardless of your interpretation of the property lines, the new dock is entirely in an area undisputed as owned by the Toby Lane Association. I'm not going to get into property rights matters. I don't believe this is the forum for that, but we are here tonight, and some of the issues that have come up would be better discussed by Brian Wall, counsel for my client. So with that, I'd like to turn it over to Mr. Wall, and then I'm here to answer questions.
Can I ask a question before you turn it over to him? Is this dock currently a Chapter 91 license, or is that part of this process?
That's part of this process.
Okay, thank you.
Good evening, members of the board. My name is Brian Wall. I'm an attorney with an office in Sandwich, and I represent the Toby Lane Association and the dock committee that Mr. Barcelli referred to. I'd like to keep my comments brief. I'm primarily here tonight because this afternoon the abutters, specifically the Ames family, that they hold the property in a trust called the A&B Realty Trust, submitted a letter to you asserting a property dispute. They are in fact an abutter to the project, but they're also part of the association, and the trust did in fact vote to proceed with this project. So we understand that at least some of the members of the trust are in favor of it. They did receive notice of the Conservation Commission hearing, and the project, as Mr. Borselli said, was fully vetted by that board insofar as wetlands issues are concerned, and that project was approved, and there was no appeal. But when we did file with this board for the wetlands permit under your zoning bylaw, the Ames family came forth and asserted essentially a property boundary dispute is what we call it. They think that their property line is in a different location than the surveyor that did this particular plan, and his stamp is on the plan. I do understand there's an attorney, Kevin Clower, is here tonight, and I think Mr. McGrath is going to speak to this. I have a couple of quick comments that are in rebuttal to the letter. First of all, as I just said, this plan is stamped by a professional land surveyor, and when the property issue came up, insofar as the location of the boundaries, we did go back and speak and meet with him, and he reviewed his work, and he stands by his work, and his stamp remains on this plan. So we think that it does adequately show the property lines. Secondly, notwithstanding the fact that we believe the plan is accurate, we want to proceed with the dock project, and we don't want to have a dispute with our neighbors or litigation. And so what we did, as Mr. Borselli did say, we went back to the conservation agent and asked, could we modify the plan and move the dock into a different configuration? And Ms. McKay said that that would be fine. And what that modification does is it renders the dispute moot, because by moving the dock away, it's completely off the disputed portion of the land. Thirdly, the property boundary dispute I would submit to you is not relevant to your review. The permit application before you is under Article 17 of your zoning bylaw, which protects wetland resources in most specifically shellfish and aquatic resources. And so the upland property boundaries really shouldn't be an issue as far as we're concerned. And finally, even if there is a property boundary dispute that has any legitimacy, it really needs to be resolved by the parties themselves or a court, not a zoning board, and I say that with all due respect. The Ames's attorney does attempt to show or tie the property boundary dispute to some regulations. He cites a regulation from the Falmouth wetlands regulations that says that docks are supposed to be a certain distance setback from upland property lines and extended property lines into the water sheet, and he claims that the dock does not meet those. Our rebuttal to that would be that this is not a new dock, it's rebuilding an existing dock, and the current dock is already in that position, and in fact, the modification, I think, makes it a little bit better. He essentially makes the same argument. There's a policy under the DEP that says that docks are supposed to be 10 feet back, or I should say, they are desired to be 10 feet back from extended property lines. I'm sorry to say that wrong, 25 feet, thank you, Mr. Borselli. But it's a policy, it's not a regulation, and again, this is an existing dock that's being rebuilt, and with regard specifically to the DEP, this does have to go through a Chapter 91 review, as Selectman Murphy did say, and so the DEP will address that when we get there. So for all of those reasons, we would ask that you disregard, frankly, the property boundary issue and just focus on whether this complies with your wetlands regulations under zoning. And I know that you have the authority separate and apart from the Conservation Commission, but we think that with the Conservation Commission's approval, that it warrants this board's approval under zoning as well. Okay. And I'm available for any questions.
Does anyone from the board have any questions at this time? Or would you prefer to hear from?
Well, I guess let me ask you something. You said that when did you did a modification to this? You moved it. So, if so, does that change the inspection reports and things we have from town departments who inspected it well over a year ago? Do they have to re-inspect the area again since you've moved the dock?
The movement of the dock is simply to swing the angle slightly, and so I would submit that it doesn't require re-review.
Okay, Mr. Chairman.
We do, just so folks know what I think Selectman Bragg is speaking of, we have two, besides the order of conditions from the Conservation Commission, we have a letter from the Harbor Master's Office, navigational issues not observed at the time of review, and mooring issues not observed at the time of review, any other issues, none, from the Natural Resources Department. There are, they have no comments on this project at this time. Any further questions from the board at this time? Yes, Doug?
I saw that the dock is going to stay in all year round. And maybe this is a question for Mr. Barcelli, as opposed to, this is not an issue on the property line.
Yes, the existing dock is a floating dock system, but it's not made of the materials that can withstand some of the icing conditions that occur, but the association has done some research on other manufacturers, and the plan is for this dock to remain in.
Will it have a bubblers system to prevent icing around it?
We have yet to determine that. We may.
Because the order of conditions requires that.
Right.
But you don't have electricity there, and the order of conditions says if you want electricity, you need to come back to get permission.
Yes. So what we plan to do is do further research, and if the plan would be to determine if the specific manufacturer that we ultimately use has determined that a bubbler system isn't necessary, then we will go back to the commission and ask for an amendment to remove that. Or if it becomes obvious that there should be a bubbler, we're going to reassess our options, and we may then seasonally remove the floats instead.
Okay. Any other question, Pat, at this time?
In the special conditions, the Conservation Commission stated that Special Condition 4 would be written into the COC and registered with, and ongoing with the deed. Now, Special Condition 4 is that any shellfish uncovered during construction should be relayed to a location approved by the Conservation Administrator and the Department of Natural Resources. Normally, you don't see that recommendation from the Conservation Commission. Usually, it has to do with the boat, how many boats can be moored at the slip. And what this condition says is no boat shall be moored overnight or for an extended period of time to the NT of the float system. The area is to be used for loading and unloading of passengers and associated gear only. Now, you mentioned that there would likely be dinghies attached to the float during
Yes.
the day or possibly overnight, which I'm sure that is okay, is appropriate. But I was going to suggest to the board that the condition that says no boat shall be moored also be a condition that's included with the, into the COC, and it becomes registered with the deed, which is normally what the Conservation Commission does. Do you have any objections to that?
No, not at all. I just wanted to make a clarification. We're talking about, the condition relates to the end here.
Right.
There will be boats on the sides.
I think that's understandable,
Okay.
considering the purpose of the dock, that the people who live there need dinghies to get out to their own boats.
How many posts are you expecting to put in? How many
There's
pipes?
a total of
Not pilings, the pipes that are going out.
3 on each side, 4 on each side, I'm sorry. 3 on each side, I'm sorry.
To 6, okay.
Any other questions before we take any questions from? I don't have a copy of this letter that was submitted, just for the record, so if anyone is.
You want one? We just got it when we came in tonight, so
I got my orange folder and it wasn't.
Yeah.
Okay.
you can read mine.
I'm just
Put a
saying that
page
we
in it.
need it submitted into the,
Yeah.
into the actual thing. Okay. Is there any public comment at this time, and then we'll bring you back, Mr. Borselli? Yes, sir.
Good evening, members of the board. Mr. Murphy, I appreciate your St. Patrick's Day cheer so early. My name's Kevin Clower. I'm an attorney with Ament Law Firm here in Falmouth. I'm here tonight with Mike McGrath and Blair Ames, one of the owners of, one of the trustees of the AB&B Realty Trust and one of the owners of 41 Toby Lane, the direct abutter to this property just to the north. Mr. Wall and Mr. Borselli have done a pretty good job of explaining part of what our contention is. There is a property line dispute. Currently, the dock is encroaching upon what we believe to be the property line. As Mr. McGrath will go over, there is some confusion. We have 3 different plans, we have 3 different property lines, we have a deed done in 1937 that's not entirely clear on, for either lot. But the current dock does encroach across what we believe to be the property line. The reconfigured plan that Mr. Borselli has prepared has removed the dock from the disputed area, but it remains within a 1.5 feet. If that's the width of this, I'd be surprised. It is not a large area. Mr. Wall was entirely correct. This is not the place for a property line dispute to be decided. This needs to be decided between the parties, either by an agreement between the parties or by the determination of a judge. However, until that's been decided, I don't believe the board should proceed with issuing a permit for this dock. There is a dock there. This is not the same dock. This is an increased use. This is a permanent year-round fixture. This is going to be entirely different from what's currently there. So to say it's not an increase in the use and to say that a dock exists, the dock does exist, but this is a different dock that's being envisioned. And until the property line dispute is cleared up, whether it be through the determination of a judge or by agreement of the parties, I don't believe it's proper for a permit to be issued. Mr. McGrath's going to go over some of the plans that have been prepared. He's prepared an exhibit that will show precisely the discrepancy in the property lines. Mike, do you want to come up? And Mr. Murray, I did have an extra copy of that if anyone needs.
I agree.
I gave mine
Pat
away.
will look, okay.
No, that's fine, thank you.
My name is Mike McGrath. I've just delivered to you a copy of a letter I've written. I also would like to give you copies of the recorded plans. There's enough copies. What I would do for the benefit of the audience is there are 3 different plans that I have given the Board of Selectmen in an exhibit. One is a copy of our survey that we originally did in 1992. And that's the plan that you have, attached to my letter is Exhibit A, and Exhibit A is colored in gray. The top lines that we found. Iron pipes on the ground. Exhibit B is a copy of the subdivision plan, and what I've done is I colored that in green. And it's obvious that there is discrepancies as far as the location. We found monuments. Monuments hold over the way that you would construct the property lines for the plan. We met with Warwick Associates, and they prepared a plan that showed the lot line in red. All of these are holding the 2 monuments here. And that's such a dramatic difference that there's only 2 ways for this to be resolved, with a judge or by an agreement. I couldn't help but notice that if this was the direction of the original, well, it almost doesn't matter. There were iron pipes that we found in here, and there's affidavits that they've been in existence for years. They have been removed. The pier was seasonal. in that I looked at aerial photographs that are taken in March, and the pier was seasonal. It's now apparently fixed without benefit of a special permit. So I believe you should look at that. I also don't think that you should be issuing a special permit if there's any kind of discrepancy in the property lines. And no matter what, there is a significant discrepancy in the property lines. So I gave this to you in writing, so you could have it. And it just seems to me that there's such a dramatic difference that this property line should be resolved before you issue a special permit. Are there any questions concerning my testimony?
Fred?
Mr. McGrath? The existing dock, how long has that been there?
It's just, my client actually put it in. Blair, you have to come up and speak to the microphone.
The existing dock was put in approximately...
Could you identify yourself for the record, please?
Oh, I'm Blair Ames. I'm the youngest member of the A&B Trust. I have two sisters that live out in the area, and they're both nurses, retired nurses. So I'm speaking for all three of us. The existing dock went in approximately 1959, and it has been my task over the last 55 years to, first of all, work with my father in maintaining the monuments, and then maintaining the monuments the whole time. It's always been a temporary dock. Before my mother died in 1997, she asked my sister to employ Holmes and McGrath to make sure that the boundary lines maintained in perpetuity and that nothing would change in the property. Anything. So it's all natural property now. I have judiciously looked at the dock, the placement of the dock, and although we were quite upset that it was placed right on the property line, because it was totally temporary, we never complained because we felt it was in good standing, particularly with John Toby, who donated the land, that everybody could use the land. And as the Knobnocket Trail ebbed and flowed back and forth over our property or over Toby Lane Association property, we never really had an objection. So it's been since the 1959, to answer your question. I've been the one that's maintained it, and to some degree, and then we had an association decide they'd maintain it over the last few years. So, are there any questions?
Has it always been an association dock then?
Yes. And it's always been removable totally until last year.
Okay, thank you. Any other questions from the board at this time? Any other public comment at this time before I open up the discussion from the board? No other public comment? I'll start out the conversation. It appears that there is some kind of dispute here in the property line, but I don't think this board is suited to be the one to handle any disputes in the property line. This board looks at the issue of whether or not it's been permitted properly through the Conservation Commission, whether or not it serves the public good, I believe, as we move forward. And I believe that this is going to be an area that would be subject to discussion at the Chapter 91 license, period. Because in fact, for them to obtain a Chapter 91 license, all parties would be subject to discussion at that time. To say that we're going to wait here would really stop the process from moving forward to the Chapter 91 process. So I think the board really needs to move this forward to Chapter 91. If they want to litigate this, the abutters have every right to be able to appeal that at the state level when the Chapter 91 level period's in. And we're not suited, nor is our town council suited, to get in the middle of a property line dispute. I believe that that dispute would be better handled by the courts and i.e. the state, where the Chapter 91 license is issued. Pat?
Well, I guess my question would be, if we approve a dock, we approve it in a certain location, and that location is not clear yet, what that might be. And I guess my question is, and I don't know if you know the answer, Mike Borselli or Mike McGrath, but was the Conservation Commission aware of the property dispute when they approved this? Do you know?
Mr. Boselli, you're the applicant.
When we went before the Conservation Commission, we applied for a notice of intent, we notified the abutters, we had public hearings. There was no knowledge of any issues with property lines until we applied to you folks the first time, and then there was an abutters notification.
Just as a follow-up, we could make any motion subject to a Chapter 91 license. So in other words, if we, when you're saying we're talking about property lines, if the state comes back and says this has to move, they would have to then come back, if we've made a motion subject to a Chapter 91 license, the 91 license, then we'd bring it back for our approval.
Unfortunately, we don't have our own counsel here tonight to.
I don't think that's right. Brent, yes, you're up next.
I have a question, actually. Mr. McGrath, if you don't mind answering my question. The diagram you presented to us, the overlays, shows the existing dock encroaching on the trust property. Does the new dock encroach on the trust property? Or is it off of the property entirely?
The plan that he has moved the most landward edge of the ramp, so it appears to be in a different location than shown on my Exhibit A.
So, is it, can you tell from this plan here, is it off of the property as you define it in your overlay?
Again, it appears to be that the landward edge has been relocated. He has a red line on there, but I don't know if that's where my property line location is.
Let him finish though.
No, that's all right. Go ahead.
Go ahead.
I want to be clear on what the plan date of the plan you're looking to have approved is.
Michael.
Mike.
The plan date is March 23rd, 2012, with a revision date of 12/28. Specifically performed to move the portion of the dock that was in the disputed area to an area that was not in a disputed area, and Attorney Clower says that in his letter. He acknowledges that.
It's 12.
But this.
Has the Conservation Commission seen this plan?
The Conservation Commission administrator reviewed this plan and made a decision that she could administratively approve what amounted to taking a section that was right there and rotating it to here. That's why there's a kink in the alignment. And that was approved administratively.
Go ahead, Brent.
And the balance of the dock remained in the same alignment that was originally approved. So the only part that changed, as in an effort to act in good faith, was to take, and if you look close on the plan, you'll see a very faint rectangular area that was where it was originally approved, and that was rotated counterclockwise, just this section. The rest remains. And that was in an effort to appease the neighbor.
For the board's edification, as some of you may know, I used to be a member of the Conservation Commission, and thank you, Mr. Borselli, for that clarification, because obviously the Commission's approval of the plan as shown, it's unlikely, in my mind, it would be unlikely that the administrator would have allowed the actual dock to be moved, but the landward portion, is a minor revision, which is why I can understand that that would have been approved. I'm reminded of, we had a seawall project before us, I think about a year or so ago, where there was some dispute over the ability of the applicant to repair the seawall and some questions about ownership. It was determined by town council at that time, I believe, that the board really didn't have any authority over the question of bounds and property rights and so on, and that our job at that point was to determine, per Chapter 91, was it an appropriate project. And so I think that this project is similar in that regard. Questions regarding the property line and the bound stones and such, I think have been resolved by moving the dock. And even if they hadn't been, I think there's probably some historical precedent here. If the dock was there since 1959, I cannot recall the number of years, but I believe that after so many decades of something being in a certain place, a property owner begins to relinquish their right to protest, if you will. And the fact that this dock is no longer on the property in question, I think makes that a moot point as well. So I'm inclined to support this.
Beck?
Well, I was just going to say, if you are making the motion, if you would agree to add special condition 6, that it shall be written into the COC and registered with and ongoing with the deed, which is no boat shall be moored overnight, or for an extended, obviously the dinghies are there, but for an extended period of time to the end of the T or the float system, and is to be used for loading and unloading of passengers and associated gear.
Well, I hate to start reading back into the record special conditions that the Conservation Commission has put in. I think the best way to do that is to make a motion that they abide by the Conservation Commission's order of conditions, which is written that exactly the way you're saying, right?
Well, they have to, well, that's true, but they have to abide by them anyway. But the question is whether or not normally the Conservation Commission puts a condition like that as written into the COC. I'm surprised that this one was not, because it has to do with the boats, the number of boats, how the boats can be moored to the docks. But, I mean, that's my suggestion, you don't have to agree with it.
No, I'm just saying that they're very explicit in their order of conditions. If we acknowledge that the conditions need to be met ongoing, I think that serves in itself. Yes, Brent, you had the question.
I guess the first part of the question is my understanding is that orders of conditions are written into the deeds, so that would already be there. If that particular order, that particular requirement in the order of conditions isn't included in the deed, it's probably because the Conservation Commission has no control over that. The commission had in years past tried to control the size or the draft of boats tied to docks, and that was considered outside their jurisdiction. And it may even be outside of ours, because we can control the construction and the approvals of the pier, but not necessarily what gets tied to it. It is something which it may be outside of our jurisdiction. But that would require some advice from town council. And Mr. Bragg, I think, had a question.
David?
Yeah, on these documents here, Mike?
Which Mike?
Oh,
Boselli
I'm
or
sorry.
Bragg?
Yeah, I'm sorry.
Okay.
When it discusses no portion of the dock or pier may be closer than 10 feet from the property boundary or extended property boundary line into the intertidal or tidal zones, does that have anything to do with the walkway that was?
You're reading from a performance standard in the Falmouth wetland regulations for construction of docks. It's not about reconstruction of existing docks. They like to see a 10-foot setback, if possible, for the same reasons that DEP likes to see 25. It just makes for a situation where docks aren't cramped together. The Ameses have extensive waterfront, so if they chose to build a dock, it wouldn't need to be right on top of where the association dock is. But the purpose of that you read is to to avoid those kind of congested areas. And we talked about that at the conservation hearing, and they recognized that this was a pre-existing situation, not we're building a dock for the first time, why are you putting it 1.5 feet off the lot line? So they acknowledged that they have a rule, but in this case, they waived it by issuing the order of conditions.
Okay, thank you.
Mr. Chairman?
Yes, go ahead.
I would make a motion that we approve this application and the plan dated March 23, 2012, revised December 26, 2012.
So that's a motion. Do I have a second? Can I ask of a motion, just there were a couple of issues that came up this evening. Number one is, if we can read into the motion to make sure that the order of conditions by the Conservation Commission is followed, and that this motion is subject to a Chapter 91 license.
I'll add that to my motion.
Is that pleases folks? So that's a motion. Do I have a second? I'll second it for discussion purposes. Comments from the board before we take any votes? Any?
I guess I would just reiterate what we said before, that I do not feel qualified to make a bunch of these decisions that we're making concerning the property line. If you assure me that the Chapter 91 law is going to take care of that issue, and that the dock can't start construction until that actually has been resolved, I will take your
Well,
advice on that one.
I'm saying that we're making our motion subject to a Chapter 91 license. I'll be happy to take comments from either of the attorneys, that they will have an opportunity to comment at the state level for the Chapter 91 license. If you want to get a dissenting view from one of the attorneys, I'd be happy to hear that. Kevin?
Ultimately, if the board is intent on passing the permit application, then we will have no choice but to continue with the Chapter 91 level. That said, as I stated, I don't believe it's proper for the permit to be passed at this point.
Okay, thank you. Brent?
Could I ask one or both of the attorneys, I mentioned earlier property rights and encroachment and such. What is the law, what does it say regarding encroachment?
Well, there's a lot of factors that come into play in adverse possession, whether it's temporary, seasonal. It's a very fact-driven analysis that is really subject for a court determination and shouldn't be looked at off the cuff.
Okay.
Well,
Pat?
I'm just going to say that I'm hearing that at least a couple of members of the board feel that there are still some outstanding issues here relative to this. And that rather than see this motion fail, I might suggest that we could continue it for a period of time until we get a little bit more information. Obviously, with a property dispute going, and I know that's not our business, nothing's going to happen until the dispute is resolved, I would think. And I think we would be in a much better position till we get some legal advice from our counsel on some of these issues. And I think it would be actually in the applicant's best interest if we continued it and not denied it. And that's a possibility based on what I'm hearing.
Could we continue to a specific date as
We
a sort of
can.
get this resolved before you come back to us kind of a date?
I don't have a problem with continuing it, but I will say that continuing it sometimes continues to foster inaction by both parties. If we move this forward, both of the parties is going to need to settle this dispute. So I think the only thing we would continue it for is a ruling from town council on whether this would be within our jurisdiction to worry about the actual property lines, similar to what Mr. Putnam was speaking about once before, and I do remember this specific case, that's not in our purview. We're not judges, we're not lawyers, and nor do we play them on television. I don't think that's something that we need to get involved in. Go ahead, Pat.
Well, I was just going to say, I don't think we should limit our ability to review the plan for other issues. I'm not so concerned about the property line. I'm concerned about the other issues that have been raised.
Well, I mean, if we're generally looking at this as an issue, this is an association dock. These are the things we look for in this community. We don't look for private docks. We look for a group of people to be able to utilize one dock for the benefit of many. Go ahead, Brian.
Mr. Chairman, I'll withdraw my motion, and I'm inclined to allow for some time to let town council provide us some advice regarding the property disputes. But I would like to point something out to the board, that council, on the one hand, has suggested that we not approve this because there may be a property line dispute, but then I ask about encroachment and adverse possession, and he suggests that we shouldn't be looking at property issues off the cuff either. So I don't think you can have it both ways.
Well, those are separate issues.
We didn't call it. Thank you.
I think they're one and the same, actually, but I'm inclined to get counsel from our own counsel and determine whether or not we should have any discussion about property lines or not,
So you're going to make a motion to continue this to a date certain? Is that what, for a ruling from town council?
Or till we have an opportunity to.
Why don't we give a date certain?
Oh, yeah,
Give us that-
absolutely.
Sure.
On the calendar?
April 1?
What do you say?
April 1?
Two weeks.
March 25 or April 1?
March 25, that's 2
That's
weeks.
too-
Yeah,
April
we'll
1?
go April 1st, is fine.
April 1st,
Wait a minute,
Oh.
yeah, that is
before town meeting. That's a week before town
I
meeting.
Okay.
would say the 25th. 2 weeks should be more than enough for town council to get back to us and define what we should or should not be discussing.
Okay, I don't have a problem with that. You can make that motion the 25th.
So with the consent of the applicant, I move that we continue this to March 25th. Was that
8:05 PM.
8:05 PM?
That would be fine with the applicant. Could I make one point and ask one question? The point that I want to make too is, it's, the flip side is, when I said that the board should steer clear from deciding property issues, the corollary of that is your permit does not confer any property rights either. And so if the dock, by way of illustration, let's assume for a moment that the dock was on the disputed land, the Ames family would have the right to go to court and file an injunction to stop the dock. So I just want the board to know, to give a comfort level, that your permit doesn't give a green light as far as property rights are concerned. The question I had is, Selectman Flynn, you said that there were some other issues. Is there any other issue that the applicant needs to address besides the property boundary issue that's been discussed?
I don't think at this time, no.
Okay, I just wanted, because if we're going to be continued, we would be pleased to address any other issues the board needs more information on. Okay, thank you.
Okay, so I have a motion to continue the 25th, 8:05 PM.
Second?
Motion and a second. All those in favor?
Aye.
Opposed? The ayes have it. Thank you. Next up is a is that totally wrong? Number 4, vote a letter of support for studying the feasibility and planning or forming a regional emergency public safety communications center. Town manager has drafted a letter, if the board remembers correctly. We had a workshop this past fall with both the sheriff's department, the county, and we spoke about the potential for even a hybrid type of dispatch. But basically, this is a letter of support for a Cape Cod Regional Dispatch Service to be studied. This is a hybrid letter that kind of catches all, but lets the state know that we're interested in studying this.
I move approval.
A motion?
Second.
Yes? David, did you have?
I think he was going to say.
Motion and a second.
sorry.
Okay. Any further discussion? All those in favor?
Aye.
Opposed? Ayes have it. Next up is an update in the finance plan of the wind turbines. David, Doug, we had a plan down there. Can you pass that plan that was signed back, please? Thank you.
So many of them.
It was the first one. Mr. Suso, are you going to do this, or are we going to talk a little bit with Heather in this presentation?
Thanks, Mr. Chairman. Assistant Town Manager Heather Harper will
Okay.
provide the summary to the board.
Okay.
You should have all received in your packets over the weekend a financial plan. And I just want to note that over the last several weeks, since the board took its vote to move forward with a process to take down the turbines, decommission them, and restore the site, we've worked with our financial advisors at First Southwest, with the DEP and the state, with bond counsel, legal counsel, and our finance director, as well as our professional staff, to provide the most detailed and specific cost estimates that we can for the board's review. The material is provided. If anyone needs a copy of what was in your packet, I have one here for those of you that read it. If not, there's a few extras. I'll just recap briefly what's included in the estimate and then be prepared to answer questions the board may have. There are 4 items included in the expenses. The first item is item A, which is wind debt, Wind 1 debt. That just memorializes that the town has issued $4.9 million in debt that has now been borrowed long-term, and the total remaining principal and interest is $5.7 million. We have existing obligations on Wind 2. The town's authorized $4.865 million in a 0% interest state revolving fund loan to be 100% forgiven upon compliance with the terms of the contract. If that is required to be paid back, it would be paid back with 2% interest, and that would have an outstanding balance due of $5,886,650. I note we're going to talk a little bit about some legal requirements that we will have as a result of borrowing for some of the existing expenses. Item C are the expenses necessary to shut down and remove 2 turbines and restore the site. The town, in the discussions we've had, would propose to seek a bond excluded from Proposition 2.5 to pay for the costs associated with the shutdown and removal. The estimated direct cost to procure, permit, dismantle, and remove both turbines is approximately $1 million. The town estimates, based on a December 2011 report by Weston and Sampson, that there are $838,000 in direct expenses. We recommend adding escalation for bidding, contract and construction management services as may required, as well as project contingency. The same report estimated $100,000 to $600,000 in potential turbine resale value. If there is any resale value, we will not know that until we've gone out to the marketplace, solicited proposals that provided the appropriate security for the town, and those responses received and evaluated. So my estimate for that range is $400,000 to $1 million. In addition, we believe there'll be additional legal and consulting work that we were associated with the project with a range of $150,000 to $350,000 until the conclusion of the project. Also included in those expenses are existing contracts with the Mass Clean Energy Center. You're all very familiar, I believe, with the REC contract. In 2010, the town received $1,010,623 in advance payment for 48,924 renewable energy certificates. The town has repaid 11,790 in advance payment because commercial operation began 90 days later than we had anticipated. The remaining cash value is $998,833. However, the town has a responsibility to deliver annually from beginning in fiscal 2015, 3,262 renewable energy certificates to the Mass Clean Energy Center. The estimated refund value is $54,808. So the range for that ranges from $998,000 to $2,054,000. And then lastly, there are annual operating costs associated with terminating the operation of the turbines. They are, and these are, we've been discussed for many months, the direct energy expenses associated with the project, which are $120,000 a year or higher, depending on rates and the wastewater treatment plant consumption, plus $106,222, which is the budget for our renewable energy budget, which includes existing contracts such as the service contract, the Power Dash contract, direct energy expenses for the wind turbine itself, telephone lines, that kind of thing, for both wind and wind 2. That $106,000 would decline to zero within 2 years. So if you turn the page, and this is a 4-page presentation, page 2 of 4, walks you right through those costs, and it gives you the estimate of the ranges presented, and those in total range from $12.251 million to $15,235,541. If there's any questions about what those expenses are, I'd be happy to answer them. Yes?
Brett?
Shouldn't that range be more in the order of $6,387,862 to $15 million? Because if we're going to talk about, you mentioned here under item 2, Wind 2 obligations, that we're looking to be forgiven that $4.8 million. So if we were forgiven that, and we're forgiven the renewable energy credits, which at the low end you're saying it's just under $1 million, it seems to me the range of possibilities here is anywhere from $6.3 million to $15.2 million.
So we did get at that at the end of the document. That includes what we know as of today's date as potential obligations. We all are hopeful and expecting that we've met all of the error obligations under the SRF loan, but that has not yet been confirmed, and we're waiting to hear back from the state, and I think Julian may have a few comments about that. But you could reduce that by the value of that contract, but that's not known at this time. Currently, we do not have that information. So at the bottom of the sheet, you'll see that there's an estimated cost to the taxpayer, and that takes into account all of the expenses, how those would be paid over a different duration for each of them, and that's on the spreadsheets in the back. But an average owner of a home valued at $471,000 will pay an estimated $48 a year in additional taxes at the top of the range for all of the expenses. The estimated total cost to an average homeowner over the life of the loans is $742. This does not include line D, which is the annual budget increase, doesn't include the annual revenue lost, and does not include the liability related to existing claims. And then in the second, and I'll answer any questions you have, I see some looking up. The second example, Selectman Putnam specifically addresses that issue. If there's some assistance from the state in this analysis, calculates what the cost to a homeowner would be if, 1, the REC contract were forgiven, and 2, the costs of the DEP loan were also determined that the town does not have to pay that back. And that for the same $471,000 home would pay $25.50 a year in additional taxes for an average cost of $344.64. Again, that also excludes the same items that were excluded in the first example.
I'd like to make a couple of comments. Again, these are ranges, and the only reason they're ranges is because we still have some major variables as we move forward. No one has an exact cost on removal. No one has, surely we have not received from the state any participation in either the REC credits or whether or not Wind 2 will in fact have the payment, the CEC as well as the REC payments. So that variable we surely hope to narrow before town meeting, but I think it's important that we get out as much information as we move forward, meaning we know where the top end is, and ultimately, we surely would hope that the low end would be zero, but I rather doubt that we're gonna predict that the state would give us that. I know that we've asked for the moon, but whether or not we receive the moon or not, I think conservatively, I think the Mass CEC and the grant would be conservative things to think that we could ask for and receive. There's one other area here that I think would be important to the voters at large if this moves through town meeting. And I know the neighbors up there have worked very diligently, but one of the variables in here is a potential litigation cost, a settlement cost of $2.6 million. It is the board's responsibility to make sure that that money is available if in fact, even if we take the turbines down and we litigate and we lose the litigation, that the board has to be able to be available the funds to pay that litigation. So I'm going to suggest as an individual that we may talk about if some of those folks would consider dropping their claims if in fact this moves forward and passes at the ballot. So that would show that there's some skin in the game, for lack of a better term, from those folks there as well, so that everybody's trying to work as hard as diligently as we can possibly work to make sure that this is successful at the ballot. And by doing that, we're going to try to work to make sure that this is the lowest price at the ballot. Let's face it, there are other competing issues that are at the ballot this year. Water, wastewater, not to say the least of. So this board's job is to try to make sure that we can cut this number down to the most palatable number we can possibly do.
Just a question, Mr. Chairman. I pulled out my notes from when the attorneys came in last year. It was from June 11th. And now I understand the 26 because it was in my notes. But my question is, if we were not successful on the litigation, is 2.6 what we need, or is that our deductible, or is it 10 per, or is that the actual 100,000 per?
I'm going to ask. We haven't really got to that point. It would be $2.6 million. What our deductible is, I think it's a minimum of $50,000 per.
So, and what I'm getting at, 2.6 may not be what we really need.
It may not be that, but it's not included in there right now, but we are going to need to include it, just as a potential possibility, because the town doesn't have the ability to pay that. The only way that we've looked into it, we've talked to our finance director, is if those claims are filed, the only way would be under the 2.5 cap. So otherwise, we would have to increase the tax rate or in a one-year thing to be able to pay that. So, in other words, we have to look at all things being equal as we move forward. We're not going to be able to pay any of this out of the budget or afford to do that. Otherwise, we're going to.
My only question was, we've had things before where the deductible was 10, and I'm just saying that's like 260,000 as opposed to 2.6 million. That was my only question.
No, it's not.
Okay.
I believe it's 50,000
All right.
per claim. Other questions from the board?
I had a question on item C, on the direct costs. According to the report that was given to WOTOP, there is the possibility that the removal would be paid for by the company, whoever is purchasing the turbines. And so the range actually could be a net negative range for that one, just for a little bit of optimism, as opposed to necessarily it's going to cost us $400,000.
But keep in mind, until this all passes at the ballot, we can only talk about what the possibility is of the low number. We have to put in the high number at the town meeting warrant as well as on the ballot, unfortunately, because, it's kind of like when we do a road betterment, we say a number not to exceed, and then we usually come back very generally on a much lower number than what the betterment actually was. Go ahead,
Well,
Pat.
there's another sentence in here that I think we should mention, and that's under item B, which is win two obligations. The last sentence says that special legislation may be required to allow the town to borrow funds for the turbines if they are removed. Because my understanding is from bond counsel that you can borrow to build an asset, but you can't borrow to take down an asset. So the monies to remove would have to be out of town.
Well, and that you bring up a good point, and Julian's going to be prepared to talk about that right now, is if anyone thinks that this is a very easy thing to be able to put together, it surely is not, because you hit
It's
on a
very
good,
complex.
good issue, that you can't borrow money unless you borrow money to do something. You don't borrow money necessarily to take something away. So the only way to borrow that money is, in fact, and Julian, can you explain what's the special legislation?
Certainly, Mr. Chairman, members of the board. Yes, we've just to echo, as we have indicated all along, there's considerable complexity here, and in many areas it's rather extraordinary. There's really no precedent set, so this has taken time and discipline to walk through with the appropriate level of deliberation, and as you've noted, Mr. Chairman, there remains some variability. One of the things that has come to our attention, and Heather Harper touched on that, is the concept of special legislation, and Selectwoman Flynn has commented on it as well. Heather has an additional handout on that, which we'd like to walk through with the board, if that would be agreeable, to give a little additional insight on the concept of special legislation, which is going to be an additional requirement that we were not originally aware of, but has become clear.
Brent might have a question.
Well, yeah, and I do have a question in relation to that, and perhaps in your presentation to us you can answer this, but I guess here we are discussing this now, but what would have happened 20 years from now when the turbines reach the end of their useful life? Would we have to request special legislation to get funding to dismantle the turbines? No?
No, the project itself would have built into it a decommissioning reserve.
Okay.
As part of the capital reserve.
Okay, do you want to go
Pass
ahead and
this
summarize a little
sheet
bit,
out,
and then
yeah.
we'll come back to answer any broad range questions?
Chapter 44 of the Mass General Laws sets forth the rules and the purposes for which cities and towns can borrow. In fact, it specifically lists out purposes. Unfortunately, it does not permit the borrowing of money to pay costs associated with decommissioning of assets, such as the wind turbines. Special legislation will be required to address the limitations of the statute with respect to this project as they apply to Wind 2 debt and funding the necessary shutdown and decommissioning costs, as well as the site restoration. A further complication is that if the town decommissions the facilities and then sells off the equipment to a non-governmental entity, the tax-exempt bonds issued to fund portions of Wind 1 and Wind 2 may become taxable, necessitating refinancing of the bonds on a taxable basis. Special legislation will also be needed to permit a refinancing of this kind. So both of those issues would have to be addressed in a special act. The town has requested that bond council draft the necessary legislation, which we believe will be rather brief, so that it may be included in the motion presented by town meeting. Town council has also advised that both the town meeting motions and the ballot questions may move forward, subject to the enactment of special legislation.
So we would anticipate further discussion on that, Mr. Chairman and members of the board, as this further unfolds.
Any questions so far to where we are right now? And the purpose of this, and I think this board will see us continue to talk about this on a meeting-to-meeting basis, because we have no firm motion as of yet, meaning the dollars and cents. I think this is a work in progress. The reason we're talking about this is we want to make folks aware that we're working as hard and diligently as possible to make sure that the motion, as well as what the ballot question would be a one-time shot, that we would have everything included in this. The last thing we want to do is come forward with something and then have it incomplete. And then it would be outside of the scope of the article, and then we would need to come back at a future town meeting. So we're trying to flush out all of this. I think it's important that we keep folks aware that the talks with the state continue, and I'd like Mr. Suso to update us a little bit. I understand the new date for the Mass CEC would be April the 2nd, which is, I believe, even after our meeting before town meeting. So it doesn't give this board a lot of time. So that would be the first time that they would take up this issue. Go ahead, Julian.
Certainly, thank you, Mr. Chairman. Yeah, just to confirm, while we had initially hoped and anticipated that Mass CEC would be able to act yet within the month of March, they have advised us that that meeting will now be held on April 2nd, as the Chairman has indicated. We've asked for an agenda confirming exactly what will be discussed, and we remain guardedly optimistic going forward, and our discussions continue in that regard. Our discussions, while these do not directly involve the Mass CEC, the discussions regarding the issue of the ERA grant funding for Win 2, we also continue those discussions and deliberations, and we have asked for a confirmation on that important issue prior to town meeting as well. But I do want to underscore that, as you've indicated, Mr. Chairman, those are two major areas, but nonetheless, I want to underscore that we have asked the state for their participation in all of the financial areas for which the town has some liability regarding the determination to remove and decommission both turbines. So that resolve continues, that discussion continues, and as soon as we have more definitive information, we'll be presenting that to the board at the earliest possible time.
I think it's also important to note that the board, the town manager, is not strictly just relying on the state, that they've taken action to work on a parallel track working with our congressman, because in fact the funding of Win 2 came through the federal government via the state. So those talks are continuing to move forward as well. So we continue to work on a parallel track on that particular funding source on Win 2. Although this board has great urgency, because we want to formulate and be able to get behind the article and its full summary of the article, it appears that the state does not have that same urgency. There was a meeting in the month of March with the CEC, that board, that was not held. So the next available meeting is April the 2nd. I'll just leave it at that we need to put as much internal and external pressure as possible on the state. And maybe the state is just looking for our town meeting to come back and send a sign and a signal to them of this community's, entire community's vested interest in moving forward with what the Board of Selectmen has moved forward. Go ahead, Doug.
Can I just clarify something, because it's coming up much later on our agenda, but it is relevant now, and that is any of the issues with the ERA grant have nothing to do with the closing out of the project from a paperwork point of view, that we will be doing that, signing some of the stuff today. It was made very clear when we met with the state, the timing of that had nothing to do with the question still being out there. It really had a question to do with fulfilling the contract, as is not running the turbines considered fulfilling the contract or not, and that was something that they were going to let us know whether, at what percentage of running them would suffice, whether it be 0 or 100% of running them would suffice.
I think that's fair to say that. Any other questions from the board? Okay, folks, this is an informational meeting for all of you. We hope to continue to work forward to come up with some kind of conclusions as we move forward. Thank you. Next item up is vote recommendation of the April 2013 annual and special town meeting. we'll get down them.
On our draft, does it make any difference about typos?
Pardon me?
On these things here, do we hear about typographical errors, or are those things?
I think we want to bring them to Heather's attention. Certainly.
Just the date on the town meeting?
Oops, yeah, that won't go in.
Okay. All right, good point right off the bat. Heather, do you want to lead this, go right down the list, and then I'll call the votes, and you want to go through what the recommendations are?
Sure.
All right?
These are drafted for the board's consideration. Article 10, update local comprehensive plan. The recommendation is as printed. I'm not sure if you want me to read the explanation.
That would be excellent if you could do so.
The local planning committee has been working to update the goals and policies of the local comprehensive plan to make the plan more functional and pertinent in order to anticipate and address the future needs of the community. The plan is a guiding document only and does not change any existing bylaws, rules, or regulations.
Okay, does the board have any comments? Let's take them one at a time to vote whether we want to move forward with these recommendations and/or explanations as printed.
I move the recommendation and explanation.
Okay,
Second.
motion and a second. Any further discussion from the board? Yes, Brent,
For Article 10, correct?
that's Article 10.
Okay.
All those in favor?
Aye.
Opposed? The ayes have it. Number 11, go ahead.
Part-time inspectors, indefinite postponement. The town has 2 full-time building inspector positions. Local acceptance of this statute is not necessary at this time.
So, do I have a motion on this?
I move approval.
Second.
Motion and a second. Any further discussion? All those in favor? Aye. Opposed? Ayes have it. Go ahead, Pat, Heather.
This is a petitioner's article to devise a method to reduce the CPA. First of all, the Finance Committee has the main motion on this since it is a financial article. The recommendation is indefinite postponement. The Finance Committee's explanation is the town is unable to reduce the amount of the CPA until 2020 according to the Modified Community Preservation Act. I just note that I did provide you all with a copy of the DOR advisory and specifically a chart that spells out the obligations under the Cape Cod communities that are part of the conversion of the land bank. And it does demonstrate that that limits the town's ability through fiscal 2020. So I have a recommendation of indefinite postponement. With an explanation, the Board of Selectmen endorses the Finance Committee's recommendation.
Now, I'm just going to make this statement to the board. Because this is a petitioner's article, I asked Heather to write an actual recommendation. It is a Finance Committee issue because it does speak about finances. So we can either make no recommendation and leave the recommendation based on the Finance Committee, or we can, in fact, also give a recommendation because it was a petitioner's article. So we have really 3 choices: no recommendation, also a recommendation, but if that recommendation is the one Heather put together, or another one as well. So.
Well, I'm thinking, when it's a Finance Committee recommendation, there have been times when we may have commented on the Finance Committee's recommendation and said that we support the recommendation. Or we could, I don't recall a time when we did not support the Finance Committee's recommendation, but there probably was one sometime.
Well, I think that those
So
times
I
did
think-
happen, but you're right. I mean, I
So-
specifically, because it's a petitioner's article, we usually take up all petitioner's
Right,
articles.
yeah.
Go ahead, Brent.
I have a question. In the notes here, it does say that 2% of the surcharge is needed to support the existing land bank debt. So that means there is 1% that it could be reduced, but according to the Modified Community Preservation Act, we can't reduce that? And I guess I'm looking for some explanation as to why we can't reduce it under, is there something in the legislation that prohibits us from reducing the contribution?
You have that
Cannot
there.
amend it.
But I thought other communities had in fact done that.
Not if there's land bank, if they're also,
Yeah.
if they're CP.
Oh, the land bank
Yes.
complicates
Right, yeah.
things.
Right.
Okay, all right.
2020 is the key date. We can at that
And-
time.
But the one thing to be clear that we did talk to town council is, and I believe that an amendment on town meeting floor would be accepted by the moderator for special for a home rule petition to change the legislation on the land bank would be allowed as an amendment on town meeting floor, so this issue could still come up.
Well, I guess in that case, if we could present special legislation to the general court, I'd be inclined to support this, because I think if there's that possibility, then I think we should explore it.
According to this, the 1% is available to support the historic preservation, open space, recreation, and affordable housing as approved by town meeting. That's what it's used for. So I think if we were going to do a home rule petition, we'd have to explain to the voters that therefore what we're asking for is that 1% be used for whatever purpose the Board of Selectmen would determine.
Or it could be 0.5%.
Or
You
it
don't
could be
necessarily have to cut it back
0.5%, yeah.
completely, but.
Well, I don't know, I wouldn't, what I'm saying is, but I don't think we'd use anything, we'd just take it off the tax rolls.
Oh, well, that's another option, too.
I think that, isn't that what the option is?
Well, it's the idea, and of course, we've discussed this with the Capital Advisory Committee, is that one option in this situation is to, let's say 0.5%, because let's say we do still want to have some money that's available for these categories, that we reduce the CPC contribution by 0.5%, and then ask for a general override of 0.5% to, basically it's a zero sum, but now we've moved that 0.5% from dedicating it to specific things to being available for a wider range of capital projects.
So it's not really, at this point, intended to just remove it entirely.
No, I think this is not
Just
necessarily.
redirect it,
It's
to
to redirect
redirect
it.
it
This
as
would be
opposed
part
to
of a
removing it.
redirection process, yes.
Okay.
And I think, and I don't want to speak for Mr. Finneran, but I think that was his thought process in
It's what it said, it's what he said on his article.
Okay, well, thank you. So then,
Well, if that's what you're speaking of, Brent, I mean, I think I could support some language. The Board of Selectmen endorses the Finance Committee's recommendation at this time, however, understanding that it, something of the nature that we cannot change the Chapter 149 until the year 2020. But we could support, future time, supporting some legislation that would give us the ability to change it. Leaves the door open, is what I'm saying.
well, if the motion can be amended on town meeting floor, though, to ask for the special legislation, then,
Yeah, but we can't crystal ball that, right?
no, we can't.
Sorry,
Go ahead.
Mr. Chairman. What you might want to do is say something like the Board of Selectmen endorses the Finance Committee's recommendation, understanding that include all of this language about which the board asked for, which I believe is informative and instructive to town meeting, about what the 2% surcharge is and what it pays for, what's available. At the end of that, you could have a sentence that says the board may consider this matter following a vote of town meeting, following town meeting.
Mr. Chairman? I think if we're
We're
going
not
to,
taking any comments when we're discussing this.
I think if we're going to modify the recommendation, I would like it said somewhere in here whether we vote to endorse the Finance Committee's recommendation or whether we vote to endorse the article itself. I would like to see something in the explanation that says that special legislation could be pursued in order to make this happen, so that town meeting understands that it could happen if we petition the general court to do so. Because the way this reads now, it sort of says, well, you can't do it at all, period.
I wouldn't mind including language saying it could be done. I would not want to include language saying that the Board of Selectmen recommended it. And I would not vote for that, but I would vote for
Understood.
saying,
We could say something like, as printed, without special legislation, the Board of Selectmen could not support this article. Right? In other words, the only way we could ever support it would be with special legislation.
but
Well,
that would imply that we'd even support it with special legislation. I don't want
Okay,
to
all
suggest
right,
that.
okay.
Or we could add to the notes down here that the Board of Selectmen may pursue a redirection of the 1% through a home rule petition, or may pursue at a later time a redirection of the 1% by special legislation parens home rule petition.
That would work.
Yeah, something like that, just to give people the idea that that's a possibility.
Yes, and that's all I'm asking
And you might
for.
get some response from town meeting on that. Maybe they say, well, we don't want any part of that, or they might say that's a good idea.
Exactly, and that's all I'm
So
looking for.
a sentence like that, that the Board of Selectmen will consider at a future time a redirection of the 1% under the home rule petition. Something like
Do you desire all these notes in here?
Probably not. Maybe that could just come under the Board of Selectmen endorses the Finance Committee's recommendation.
Yep.
However, the board may at a future date
Good.
consider redirecting the 1% through special legislation
Okay.
as a home rule petition.
Don't forget that will mean we lose $700,000 in state matching.
Understood, and that would be
Well,
part of-
that's true,
I think-
and that would have to be,
And I like that language. I think I would be inclined, if the board would be agreeable, to include this language here so that folks understand
this whole chapter thing.
Exactly. I think my only concern here, and all I'm asking from the board, is that we give town meeting all of the information so that they can either vote this up, vote this down, or have a discussion about it.
We can have,
Go ahead.
I have the sense of the board, if with the chairman's discretion, he can review the final recommendation and explanation. The recommendation would be,
So we're gonna include these
Yep.
notes, though, in some form or
Yes.
fashion? Okay.
Yeah.
Does that sound fair?
Yeah, that sounds fair.
So the motion would be indefinite postponement with the notes and the expanded with the legislation. Someone have that motion?
I'll make that motion. Second.
Do I have a second? All those in favor?
Aye.
Opposed? The ayes have it, okay. Heather?
next item, Article 13, the board voted last week, indefinite postponement. Explanation, this matter is best determined by town meeting and should be properly presented to the town meeting Rules and Procedures Committee.
Okay, do I have a motion?
I'll move it.
Motion, and do I have a second?
Second?
All those in favor?
Aye.
Opposed?
Opposed.
The ayes have it.
Article 15 is another petition article, excludes Wind 1 debt obligation, indefinite postponement. The Board of Selectmen has voted to see if the town will exempt from the provisions of Proposition 2.5 the remaining debt obligated for the construction of Wind 1. This article, as presented, is incomplete, and the board recommends that the town consider this request at a special town meeting as presented in Articles 21, 22, and 23.
Do I have a motion?
I wonder if we need to put in the first part of that sentence, in the special town meeting, we have, I'm just wondering if we need to put that earlier. I'm not sure it really matters, but
What are you talking about, Doug?
when the explanation says the Board of has voted to see if the town will exempt from the provisions, and I guess I would kind of immediately want to say in Article 21 of the special town meeting, and maybe it's redundant to put it twice, but that's where we're agreeing with this idea, we're already covering it in our own article, and maybe it's not necessary to put it again, but
And just reverse the two sentences.
Reverse the two sentences.
Okay.
Yeah, that would work.
Okay. So,
yeah,
do I
thank
have
you.
a motion then?
I'll move it.
Move it?
Second.
Motion is second. All those in favor?
Aye.
Opposed? The ayes have it. Article 18, reorganization. Go ahead.
The recommendation is that the town vote to accept Article 18 with the following modification. Delete natural resources technician, grade G7 with a rate of $17.10, range to $21.63. And that, again, is consistent with the board's vote. The explanation is the Board of Selectmen recommends the creation of a Department of Marine and Environmental Services. The proposed merger will more efficiently utilize town resources and will better serve the many needs of our coastal resources.
Just
Yes,
a
go ahead.
question. So we originally thought that we would create it and keep it in the personnel classification, but not fund it. And now we're just deleting it entirely. Is that what we're doing?
My understanding is that's
Yes.
what the board voted to do.
To delete it.
I move it as written, Article 18.
Second.
Motion and a second. Any further discussion? All those in favor?
Aye.
Opposed? The ayes?
No.
No, okay. Okay. Article 26.
road takings, the recommendation is as printed. The explanation is the Board of Selectmen held a public hearing on March 4, 2013, at which time no opposition was heard to taking of these roads as public ways. The roads will be taken without betterment assessments because they meet the town standards for acceptance as reviewed by the Planning Board and approved by the Town of Falmouth Engineering Department.
Do I have a motion?
I'll move it.
A motion, and a second?
Second.
All those in favor?
Aye.
Opposed? The ayes have it. I'm going to go back to number 18. I thought we created the position but did not fund it.
Then we had another vote.
But then we had
and
another vote.
The fact is, you were not here, the vote was 2-2, so it was a tie, so it didn't pass, right?
Correct.
Right.
To keep it, so,
Wait a minute. If we already had created it, and then you had a 2-2 vote, the original vote was the one that passed.
no, I can't, how did it, Brett, you were here.
We
How did
already
that work?
created it, and then you
Was
had
I?
a 2-2 tie.
Maybe you were not here.
Whatever was created was created.
First, I brought it up in the budget item,
I know we talked about it in the
Then-
budget, and we decided not to fund it.
and then, yeah, but that was just not on the warrant, that was through the budget process. We said we'd leave, someone said we'd leave it, then when it came up to on the warrant article, I said, why is it still in there?
I remember you saying that.
And, yeah, so,
Heather remembers.
Go
And
ahead.
ask Julian to confirm the sequence of events. Sequence of events was the discussion of the merger where the board voted the organizational structure.
Right.
Then there was the town meeting article, which was placed on the warrant, including all the positions.
Right.
The Board of Selectmen has to vote affirmatively by a vote of a majority of three, or
Four.
of four, I'm sorry, a supermajority of four to create the position. The vote of the supermajority failed, therefore the position was not created. I wasn't there for that either, but.
Okay.
Even though it was in the warrant, but we did not vote to create
Well,
it.
I do remember that we decided not to fund it, but I thought we had created it, but.
Probably.
No, we didn't.
Okay, all right, that's fine.
So,
That's my memory as well.
All right, Article 28,
27.
27, I'm
It's
sorry.
the authority to dispose of Spring Bars Road. The recommendation is as printed. This article grants the Board of Selectmen the authority to determine the appropriate method to facilitate disposition and to dispose of this 11.39 acre parcel in accordance with the Community Preservation Act and other governing laws or regulations. This is a necessary procedural vote to allow the town to move forward with the development of affordable housing as planned in accordance with Article 1 of the special town meeting of April 2010.
Do I have a motion?
I'll move it.
second.
Motion and a second. Any further discussion? All those in favor?
Aye.
Opposed? The ayes have it. Just for the board's information, came up as, in a workshop we had with the state, that many folks thought we had already proceeded to do all that was necessary to do, but one of the things that came up was that the Board of Selectmen needed the ability to really declare this surplus property by a vote at town meeting. So this really gives that board that opportunity to do that. Okay, Article 28?
Rental registration fees, the recommendation is as printed. The explanation is this change will allow the Board of Selectmen to establish appropriate fees for the registration of rental property in accordance with its annual fee hearing procedures.
Okay, do I have a motion?
I'll move it.
Second?
Second.
All those in favor?
Aye.
Opposed? Ayes have it. Special town meeting, land acquisition.
Recommendation is indefinite postponement. The explanation is the town is in active negotiation with the property owner, and the board will make its recommendation at town meeting.
Okay, we have to give,
Oh, I know.
we have to give
I was just trying to remember what it was.
Oh,
Okay.
sorry.
so do I have a motion?
Move Article 19 as written here.
Second.
Motion and a second. Any further discussion? All those in favor?
Aye.
Aye, opposed? The ayes have it. Mill Road easement.
Indefinite postponement. The Procurement Act requires the town to issue a request for proposals. Responses were due March 9th, 2013, and are currently under consideration. The board will make its recommendation at town meeting.
Do I have a motion?
I'll make the motion, Mr. Chairman, Article 20.
Do I have a second first?
Is there- Second.
Okay.
My question is there any other option that we could forward that we're making it very clear we're going to make, both on this article and next one, that we're going to make a positive recommendation, that our recommendation really isn't necessarily indefinite postponement. In some ways, I think people read that saying, oh, we're against the motion.
Well,
When
let's
we're
start
not,
with the
we're
Mill Road one first. You talk about the Mill Road one or the wind turbine?
I'm talking about both of them. That, I mean, we're expecting that, we are fairly confident by the time town meeting comes up, we may have a Mill Road recommendation to make, a motion to make that's positive. Similarly, we hope to have one, and I don't like the idea that we're coming forward as if we're against any of these three articles. Heather?
The next one does state that you intend to make a positive motion.
I know, but I'm just even the recommendation itself being indefinite postponement.
Yeah,
I don't know if we have any other option
no.
besides that, but.
You don't.
David Vieira is quite specific that you either recommend or, definite postponement. We could put some language in there that the board is actively working to come to some final agreement to be able to move this forward at town meeting. But I think, we cover it by the board, will make its recommendation. Go ahead, Brent.
Would it be appropriate perhaps, and I'm looking back because we just did this with Article 19 that we just voted, saying it will make its recommendation at town meeting, but perhaps instead of saying that the board will make its recommendation at town meeting, in each of these cases, what we want to have is language that says something to the effect of the board may modify its recommendation at town meeting. Because we're making a recommendation. So for us to say that we're going to make a recommendation at town meeting, well, we're recommending indefinite postponement.
Can we say plans to make a positive recommendation at town meeting?
I would prefer to say something like, I think the board at printing of the warrant did not have sufficient information to make a positive recommendation, and will, if that information is gained, would make a positive recommendation on the town floor, or something to that effect.
I think the problem is we don't have the language to even make a recommendation. We don't have the current language to say we recommend it. So to say it now.
Oh, no, well, the recommendation would still say indefinite postponement. I think what we're talking about, the explanation would be a little bit different.
Oh, you're talking about, because, well, no, but if we're expecting to have a positive recommendation and have it completed by town meeting, we can't say anything other than indefinite postponement because we don't have language.
We're not talking about the recommendation, we're only talking about the explanation to let them know we're continuing to work and we may have a conclusion for it. Go ahead.
Can I just read what I think I heard?
Yep.
The board, at the printing of the warrant, did not have sufficient information to make a positive recommendation and hopes to make a positive recommendation to town meeting.
That's good.
That sounds fair.
And I would include that
I'm
for
okay
Article
with
18
that.
also.
Yeah.
So let's do, for which one did you say?
18 and 19. I mean, 19 and 20. 19 and 20?
Well, I think 19 might be a little premature because you folks don't even know what we're talking about there yet.
Yeah, I did not.
Well, okay, all right.
I don't know. I thought-
You want to go back tonight? Let's
No.
open 19 back. Pardon me?
No? We're only talking
Still
about 20.
very
Yeah, let's talk
very
about 20.
premature.
Yeah, right. Especially in land acquisition, I think you'd send the wrong message.
Well, for 20, make that, well, there's already a motion for 20.
No, all right. Who made the motion? You?
No, Dave made the motion, Doug seconded it.
Do you want to pull back your motion and change it to what Heather said in that explanation?
Absolutely.
Same with second.
So you're going
Yeah.
to motion what Heather said and
My
Doug?
motion for Article 20 is including the explanation that Heather has over there regarding the process, definitely.
Okay, so Doug seconded. Any further discussion on the board? All those in favor?
Aye.
Opposed? The ayes have it.
Mr. Chairman?
Yes.
If I could just make a suggestion for Article 19, that we change the word will to may, or we change this to say that the board may change its recommendation at town meeting. Is that fair? So right now, what we have is the town is in active negotiation with the property owner, and the board will make its recommendation at town meeting. In fact, we're making a recommendation here, which is indefinite postponement. The explanation would be more appropriate to read, the town is in active negotiation with the property owner, and the board may change its recommendation at town meeting.
That sounds fair to me.
So I'd make that a motion.
The board may amend its recommendation or change it.
Well, it would
Means the
change,
same
it
thing.
would change our recommendation is what we would do. So rather than will make, the board may change its recommendation at town meeting.
Heather, do you have a problem with that?
No.
So you're gonna make that motion? Do I have a
Yes.
second?
Second.
Second? So we're back on 19. All those in favor?
Aye.
Aye. Opposed? The ayes have it.
Thank you.
Okay, Article 21, wind turbine, exclude all Wind 1 and Wind 2 debt. Go ahead, Heather.
Indefinite postponement with an explanation. It states, in an effort to resolve the well-documented concerns about the operation of the town's wind turbines located at the wastewater treatment facility on Blacksmith Shop Road, the Board of Selectmen intends to make a positive recommendation on the floor of town meeting, with our goal to bring this matter to closure through a townwide resolution and with the hope of restoring community harmony. The board has set in motion a process to shut down Wind 1 and Wind 2 to decommission the turbines and restore the site.
Could I just add some language after the first line? Selectmen intend to make a positive recommendation on the floor of town meeting once we have additional information. Is that fair to? Or something to that effect?
Yeah.
Again, trying to reconcile the
Yeah.
explanation with the motion, which,
Can you repeat what you're saying? again?
selectmen intend to make a positive recommendation on the floor of town meeting once we have additional information.
How about once we have all
Once we have all information.
the information?
We don't usually put first person in it, so do we need to make that passive?
Once it has all information, or once the board has all information.
I'm sure I hope we
Point of order?
No, no discussions from the audience in regard to this at this time. Thank you.
So I would make that my motion, that we approve the recommendation and the explanation as amended.
Second?
Motion and a second. Any discussion from the board in regard to that? All those in favor?
Aye.
Opposed? Ayes have it. Article 22, wind turbines and fixed costs, fund costs. Heather?
The recommendation is indefinite postponement. The explanation is the board will make its recommendation at town meeting.
Could I amend that to say the board may change its recommendation at town meeting once it has additional information or all information? And that would be my motion to approve the recommendation and the amended explanation.
Motion, second? Do we have a
Second.
David, okay.
My question is just, as opposed to using the language we used on Article 20, that we expect to make a positive recommendation on that?
Go ahead and explain how you'd like that to be then, Doug.
I would prefer the language that we used in Article 20 for this one also, or even the explanation of Article 21, at least. I would like to, in the explanation, suggest that our hope at this point is still to move forward in making a positive recommendation on this.
Well, I think it's fair to say that in these three articles, that the board, we talked about a funding range today. Whether the funding range is on the high end or the low end, I think it's fair to say that the board is going to make a positive recommendation. I think we've discussed this at length. So if we can imply that in some form or fashion, I would prefer. I really don't have any idea why we don't even make a positive recommendation. We would give all the explanation and the final information on town meeting floor.
Because we have no idea of the numbers, and it sounds like also we have the bonding issue and how we're
Yep.
actually funding it.
Well, I
is
mean,
still unclear.
this article really needs to be written explicitly well. Okay.
Did you want to add the positive words then?
Yeah.
Mr. Chairman, do you want to say,
Sure.
for instance, the board will change its recommendation to a positive recommendation at town meeting once additional information is received?
I'm agreeable to alter my motion.
Yep, okay. So you have a motion, second, okay? All those in favor?
Aye.
Opposed? The ayes have it. Okay, next one, Heather.
Okay, to supplement the budget to offset lost energy, the recommendation is that the town vote to transfer from certified free cash $140,000 for operating budget deficits resulting from the shutdown of Wind 1 and Wind 2, said sum to be expended under the jurisdiction of the Board of Selectmen. The explanation is the funds requested will provide for 2 months of energy costs for fiscal 2013 and the projected fiscal 2014 energy needs for the wastewater treatment plant if the wind turbines are shut down and no longer provide energy to meet the demands of the wastewater treatment facility.
In the recommendation, do we have to list both budgets that we're transferring it for? Or does this cover it well enough to say?
That's, the finance manager is satisfied with this.
Okay, great.
So do I have a motion?
Move Article 23 as suggested.
Second.
Second, motion is second. Any further discussion? All those in favor?
Aye.
Opposed? Ayes have it. Article 24.
You gonna read it?
Well, Mr. Chairman?
Yes.
These are really policy recommendations. The Finance Committee, I know, is awaiting taking up these issues until they hear the board's position on both of these matters. They both will have the main motion of the Finance Committee as they are fiscal issues. So I have drafted some thoughts on both of them following your presentation last week for the board's consideration. First one relates to the water filtration system, and the second to the wastewater, comprehensive wastewater management plan.
Go ahead, Pat.
So I think it should be the Board of Selectmen recommends that the town appropriate $3,400,000 for the purpose of designing a water filtration system for Long Pond, subject to an affirmative vote to exclude the cost of borrowing from the limitation of Prop 2.5, and I would move it.
So that's your motion?
Yeah, just
Do I have
add
a
an S to
second?
recommend.
Second.
Now, are we going to do, just this is under discussion, are we going to do a explanation, or are we just going to do a recommendation?
This is a policy, as I understand, so it's not really our motion. The Finance Committee makes the motion.
Okay.
But we're sending them this message.
Okay.
That we support this.
Okay.
That's really what it is. So this is really not the article.
Okay, so a motion and a second. Any further discussion, Doug?
At one point, we have to make a recommendation as to which train we're recommending, don't we? Is that what our next item is on the agenda? As to, our agenda says that we're discussing and vote to recommend water filtration plant design. Is that just the funding of it, or is that actually what was brought to us and we need to choose which plant design we're going with?
Heather?
That value is estimated to cover the optimum design recommended by the Department of Public Works. And just a further note, I haven't asked for additional estimates, but my sense is that the value to design is not going to change a whole lot if you take one piece. In fact, that would be to design the whole train, but the board may consider, as you get the prices in for the construction costs, as the design develops, to do a modular implementation.
My interpretation was that we fund the design this year, look at what the design is, then we have hard figures, and then we can decide next year what we're going to do in the design.
But we have to tell them what to design. You can't do that, and we have to say, we want you to design
Right.
train A, train B, train C, not go ahead and design, then we'll tell you later what we wanted. At some point, we have to make that decision.
I agree with you.
And it-
Go ahead, Brent, and then Pat.
Well, right now, we're just recommending, and I'm guessing based on Ms. Harper's comments, that this is not to exceed, that 3.4 million would be the most that we might need for a design, regardless of what train is chosen, excuse me. And so, maybe in the next few weeks, we have it on the agenda to finalize our recommendation so that there is, as Mr. Jones noted, an actual, something that we know we're designing, and we're not just sort of tossing it up in the air.
Well, and the other piece to that is, we need to get this on this ballot, number one, and we haven't made that, but if we don't spend all of it, it just gets reappropriated to something else, so it isn't like it's there and you have to use it. It would then be reappropriated like any other article. So there's no loss, and we should, at some point, discuss it. So we can be, I think we need to be able to tell town meeting, too, what it is we're proposing. So we should have it on the agenda before town meeting, if we can do that.
That's a good question. My question to Heather is, because this is a debt exclusion, am I mistaken? Or is this capital exclusion? What is
Debt.
debt exclusion? If we don't use all the money, can we reappropriate the additional funds for other things, or do we have to use all the money?
We can't.
You have to use it for the purpose
That's
For
described.
which, oh, okay.
Right, so
So I was
it's
wrong.
unlike a budget item
Right,
that left over, right?
Okay.
But we would not have to borrow all the money.
Right, right.
correct.
Yeah, we just went borrowing all
And
this, right.
just a note, remember, the town meeting article does not include the sum. I mean, the warrant, the ballot question. The ballot question includes the purpose.
Right.
You
So-
only borrow what you need.
So why don't we do
Oh,
this?
that's true, right.
Why don't we do this? Why don't we put this on, make this recommendation, and then on our meeting on the 23rd, we'll make, the board will take it, 25th or whatever, make a final recommendation on the train that the board chooses. Okay? Does that sound fair?
Yeah, that sounds fair.
So we have a motion and a second?
Yes.
If I'm not mistaken. All those in favor?
Aye.
Opposed? Ayes have it. Article number 25, go ahead.
I would just add, change recommend to recommends, change a D to an S, and leave all the other language as written.
Okay, Heather, Brett.
Mr. Chairman, I do wish we had a little bit more time to discuss this whole plan because it was only presented to us last week, but I am not in favor of the 4.5 million for the engineering design. As I noted last week, I would prefer that we get some details back about some of the other pilot projects before we embark on an engineering design. I understand, obviously, that we have presented a plan to the state. The state, I think, understands that we are serious about what we're doing here, and I think if we were to wait to get some feedback from some of these pilot projects, it would probably behoove us financially to know for sure. And I think it would also settle some of the critics, because if there is any question, and I know there are some, and our wastewater superintendent is one of the very vocal critics, that there is no solution except for a sewer. But clearly there are people who disagree with him. And if we wait to get feedback from these other pilot projects, it will either prove him right or it will prove him wrong. But either way, it will help settle some of the issues and some of the questions, and then we will be able to definitively move forward. Whereas if we proceed now with this engineering design, there's going to be pushback. There are going to be individuals who are they're going to voice the same things that I'm voicing now, that we want to see the results of the other studies first, that there is no proof in this and there's no proof in that. I think we can settle all of those arguments by being patient here and waiting a little bit to get the results of some of these other pilot projects.
Pat?
Well, my understanding is that in the comprehensive wastewater management plan, the sewering of Little Pond is part of the plan, and we did vote to send that plan. It was always, forever, as long as I can remember, that section of town would be sewered, not only because it's dense, but also because the treatment plant needs additional stuff to keep it functioning properly too. And that's probably may be the one and last time that we sewer any other place in town. This may be the only one. The second piece to that is that the other innovative alternatives, like the inlet widening, the compost toilets, some of the others that are being studied, it would probably take a minimum of 3 years to get any really good information about the validity of those options actually reducing nitrogen. The other part is that this is the window in our debt program where this money is available. So we need to appropriate it now because the window is open. And the other reason is that it's important to do this because it's part of the plan and it's what we said we were going to do. And now if we change it, then we would have to probably modify the plan that we sent to the state if we don't do this, because, I don't know, but I'm not sure, but the chairman of the committee is here and maybe he can be more definitive than I am.
We're not taking any comments out there from the
Oh, we're
audience.
not taking
No,
comments,
okay.
right. Well, those are all the reasons that I would say it's important to appropriate it now because the money is available, it's part of the plan. Other modifications could happen even if the money is appropriated. but we need to do that because we agreed to do it, it's in our plan, and I think it's expected that we will do it. I think the results of the monitoring of the innovative alternatives will be really important, and I support those, and I hope that they do yield very good results in removing nitrogen, whether it's the oysters or whether it's any of the other alternatives. But I think that we've made this commitment to do this sewering of Little Pond, and that project has to move forward. Also, if the project on Little Pond is going to go forward too, it's going to require the sewering, because that's all tied together with the Little Pond housing project as well. So those are all my reasons for supporting it now.
You can speak to
Anybody else?
Go ahead, you had your hand.
Well, first of all, I understand that it is one of those windows of opportunity, but that doesn't necessarily mean we have to jump through it. I think just because the money may be available to spend doesn't mean we have to spend it. What we sent to the state was a draft plan, and it was not a final plan, and it's always been understood and always been, at least what's been communicated to me and this board, in my understanding, somebody correct me if I'm wrong, is that the plan is adaptive, that it can always change, and that we can always make adjustments to it. And finally, one of the things that was mentioned was that the Bournes Pond widening, we may see immediate results from that. And one of the questions, of course, that I asked, and I didn't actually, in my mind, receive a satisfactory answer, is, well, why not widen Little Pond Inlet? Because that, if it's going to give us an immediate relief, then maybe we don't need to sewer. So those are just some things to consider. I think that there's nothing cast in stone here. But one of the other things, too, I'd like everyone to consider is that we have on the ballot, we've got $3.4 million for the wastewater, or the water filtration design. We're going to have this article, which has a number of items in it. We're going to have one or more articles regarding the wind turbines. There's going to be some pushback. And the question is, do we want to risk pushback on this article? Because there may be a lot of folks out there, there may be enough who say, you know what, let's wait on that 4.5 million. And then these other two items on here, the 300 for the Bournes Pond widening and the 800,000 for the upgrades, those could get lost in this if enough people say, you know what, we want to wait on that 4.5 million. So that is something to consider.
Okay.
All
right, go ahead.
Well, I just want to say that the Water Quality Management Committee has been working on this for 3 years. And they have presented it to us on numerous occasions. We have supported the work that they've done. We've supported the CWMP, and it has to be in by December because we have a consent order on the discharge plant. So we really don't have time to change the plan at this stage because we are committed to what we presented, and we're committed by consent decree to have all of this done by December. I met with the Water Quality Management Committee and some of the town staff with the Cape Cod Commission last week, a week ago today, and the Cape Cod Commission has agreed to help with some of the funding for some pieces of the project. They also have agreed to help us move our plan through the state in a very positive way. And I think that it would be wrong at this stage of the game, when we're practically at the end stage, not to appropriate this money now and not support this plan going forward. I just think it would be detrimental to the town, detrimental to the plan, detrimental to the project, because it's something we have committed to for a very long period of time.
I'm going to talk about something that's going to be kind of right down the middle here, and take a little bit of what you have to say, Brent, but take a lot of what Pat has to say. I think the $4.5 million is very important at this time, and let me explain to you why. We're all talking in general terms about what the cost of this process is going to be. When we actually have a design of this particular area, we're going to be able to then sit down, and we're no longer going to be talking about conceptual plans, we're gonna talk about a plan. We're gonna actually have cost of what it would cost to implement that plan and install it. We're then gonna wrestle with the idea and the ideal in this community about what the share of betterment would be. What the actual cost for the folks' operation would be. I mean, let's face it. So then folks are gonna have some serious decisions to make after after the design is done. Do we wanna wait a year or two? We made a design on something, but the folks then have an opportunity, the voters, town meeting, we're gonna have an opportunity to say, maybe we should try these alternatives. Maybe we'll get everybody else on board. Maybe we won't. Maybe we'll be able to find out as a community that this is a plan that's affordable, a plan that the folks there can move on with their lives, figure out how they're going to improve their properties, because many folks are waiting to be able to improve their properties on that peninsula there. So I think it's an important piece of the puzzle. I'm looking forward to the next step. The next step is we really need to start engaging. It's no longer just the community paying for just the designs and everything from that forward. We're going to get to the point where the next step is going to be, how are we going to fund this as a community totally? Not dribs and drabs, and I agree with you. This window of opportunity, folks really need to understand. I believe that it's a great financing tool for us, but it's not a done deal. The voters still have to accept to replace the debt. So we need to work hard to be able to explain it. So I'm taking a middle road here. I think it's important for the $4.5 million because you don't know what the costs are going to be until you design it. You don't know what the expectations are of those folks in the community. And I think this is a valuable thing. Just like we spend $500,000 to check to see whether Oyster's working on or other alternatives. This is an important part of this puzzle. We spend the $4.5 million to design this system, see what the actual costs are going to be, see whether the neighbors have buy-in, then we can move forward. So I think that's the middle of the road here. No one says we're building that the next year, because we have to get buy-in then from those folks. And again, we're moving down a parallel track. If something happens and we find one of these alternatives is a home run, well, let it be. But go ahead.
My only comment is then we'd have spent $4.5 million for nothing.
Well, if we find out an alternative is going to save us $60 million, that $4.5 million was a good investment to show folks what the alternatives are. What were you going to pay for this? What were you going to pay for that?
And then, if I may,
Yep.
one more comment. The Little Pond area is very densely developed. It even includes the mall and all of that. And that's why sewering was always the optional remedy to that area when it came to wastewater, that the alternatives would not work very well because of the way it's set up.
All right. So, right now, we're on the motion. We haven't had a motion, but this...
I made a motion.
Oh, you did make a
Yes.
motion. Did we have a second on this motion?
Second.
Motion and a second. Any further discussion on the board? Points well taken. All those in favor?
Aye.
Opposed?
Opposed.
Ayes have it. And that is all of our motions. Okay? Just for the board's edification, we will have an opportunity after town meeting to make a decision on whether, if in fact both of these items pass at town meeting, whether to combine them or not combine them, move it to the ballot. So we'll have those decisions to make as a board. Next up would be approve the minutes of the meeting of March the 4th.
I have one correction.
Sure.
See if I can find it here. What did I do with my minutes? Anybody have a copy I can look at? I had mine marked too. One more minute, and if I can't find it, I'll quit.
It's all right. Do you want me to move forward with the summary of actions?
Let me take a look here, see if it might be in there.
No, that's okay, I think,
I'll tell you what, why don't we come back to this while you look at that?
okay.
We'll move to the summary of actions. We'll go right to the proclamation, Woods Hole Model Boat Show Weekend. Doug, you want to read that into the record? Make the motion.
I move, whereas in view of the Woods Hole Historical Museum's role in preserving and enlightening the community about the history of the coastal village of Woods Hole, and encouraging the education and participation of the public at large with exhibits, walking tours, talks, traditional craft workshops, and teaching traditional boat building skills. Whereas the museum is hosting the 9th biennial Woods Hole Model Boat Show and encouraging hundreds of visitors and exhibitors to come to our town during the spring season. Therefore, we, Kevin Murphy, Brent Putnam, Mary Pat Flynn, David Barrett, and Doug Jones, as selected of the town of Falmouth, do hereby proclaim April 13th and 14th, 2013 as Woods Hole Model Boat Show Weekend.
Do I have a motion?
I'll make that motion to approve.
Second? All those in favor?
Aye.
Opposed? Ayes have it. Number 2 would be requests for parking meters. I believe that the term should be not to be, violations not to be enforced for the Woods Hole Museum, Woods Hole Model Boat Show and Woods Hole Museum for April the 12th at 3 p.m. and then April 13 and 14, all day. And then number 3, approve request for special event, Daffodils Day Spores Garden, April 20th and 27th, 2013. And then 4, clarify and authorize the town manager to file SRF documents. So if no one's holding any of those items, I'll call for the vote on articles on summary number 2, 3, and 4. Do I have any comments?
We need a motion to approve.
Right.
I would so move.
Motion?
Second.
Motion second. Any comments from anybody? All those in favor?
Aye.
Opposed? Ayes have it. Okay.
Found it.
Well, now we'll go back to the minutes.
Last page of the minutes.
Okay.
About a third of the way down, it says Article 15, petition, exclude Wind 1 debt obligation. It says discussion continued, possibly recommending indefinite postponement. This is the article that's in the annual town meeting. This is a petition article from Kathy Elder. And it says possibly recommending indefinite postponement because our article has the necessary language to transfer the debt, dash, we agree with the intent of this article, but ours does what it needs. I think we didn't vote on that. I know Brent said that he supports the intent of the article, but we didn't vote to support the intent of the article, so it shouldn't say, I don't think it should say that. I think it should just say that because our article has the necessary changes to transfer the debt and does what it needs to do from a legal point of view and eliminate the other language.
Well,
You can,
we may not have voted it, but does the board agree or not with the intent of the article? I mean,
well, I don't agree with it because I don't think it's a complete article. It doesn't have any funding in it.
It's not agreeing with the article, it's agreeing with the intent of the article, which we all, in our discussion, we talked about the fact that our articles did the same thing, so therefore the intent was the same. That's my take on it.
Yeah, I know, and we just have a different point of view.
Agreed.
So it shouldn't say,
I think both of you expressed your point of view that evening, if I'm not mistaken.
we did, but to say that we agree, we don't all agree. We could say some agree with the intent of the article.
Is that fair to say?
That is fair to
Do you want to say
How about we
some?
change that word, we?
From we to some.
We agree, how about some agree?
Thank you.
All right. So there's a motion
And with
to
that, I will
accept
move the
with that,
minutes.
the word some.
Second.
And a second. Any further discussion? All those in favor?
Aye.
Aye, opposed? The ayes have it. Next up would be reports from the town manager.
Thank you, Mr. Chairman. No formal report beyond what's been commented on this evening. Thank you.
Okay, just before we take any individual selectmen reports, I wanted to make a comment to the board that, again, the CEC is meeting on the 2nd of April. Town meeting, I believe, begins on the 8th of April.
Yes.
So we would need to have some kind of meeting with the board to be able to clarify and make a final vote on our article, because I think it's going to be very important, because this article is going to be complex, that we have this article printed and potentially for the newspaper for Friday's edition, so that folks know what the actual article is. So we may need to have a meeting either on the 3rd or the 4th for some form or fashion.
The Thursday is the, I know at least precinct 1 and 2 precinct meeting.
Well, I think it's only a meeting that's going to take us, what time precinct meetings? Typically 7 o'clock? So we could have like, 5:30, 6 o'clock meeting for 15 minutes, but I think it's important to get it out there. I think if we did Thursday, maybe we could ask Mr. Kazarian, if we gave you the article, Thursday, would that be too late? Thursday, if we had a meeting on Thursday evening, I just want to give CEC time to be able to communicate back to us.
Like at 6:30, could we meet at 6:30?
Well,
Because I have a meeting at 5 that
I was
night.
going to say, I don't know what all the precinct meetings are yet, but.
They are 5 and 6.
On what day?
On Thursday, and
Oh, the
also
4th?
Creeks 1 and 2 a meeting.
Oh,
So we got a lot on 5 and 6, so 6:30 would be hard.
too late,
So
yeah, we couldn't
why
do
don't we
that.
do like 5:30, 6 o'clock? 6 o'clock would be fine.
Yeah, okay.
Is that all right with the board?
Mhm.
Then we can come up with our final, I don't think it's fair to anybody if we formulate the article the night of town meeting in the recommendation.
Right.
That sound fair? Okay. Anything else that the board wants to take up?
I do.
Yes, go right ahead.
Now, Brent, I want you to know, I'm not on your case tonight, but
We can agree to disagree.
I know. Well, I want to say at last week's meeting, which went on to midnight, Brent advised us at 10 of 12 that we couldn't meet past 10 o'clock. And I didn't really
Well-
challenge you, past midnight, because I wanted to leave at midnight too. But actually, the open meeting law does not require that a meeting be adjourned at midnight. Once your meeting is begun, you could meet for 3 days if you had the
You couldn't
stamina
have
to
kept
sit
that to
there for
yourself.
3 days.
You couldn't have kept that to yourself.
Well, because I think it's important for other boards to know that if they meet, if something goes on, not that any of them want to, but if they choose to go beyond 12 o'clock, they can, because it doesn't matter when you end it, it only matters when you begin it.
See, and that's interesting, because when I was on the commission, the Conservation Commission, we were always, at least our understanding, of course, maybe it was a change to the open meeting law, because at the time, we were advised that we couldn't go beyond midnight because it was a different day. And of course, I had always believed that, because with town meeting, we always stop at midnight, no matter what.
Oh, but that's a town meeting rule, that's why.
Oh, okay.
Oh, yeah, that's a town meeting rule, that you have to stop at 11, or if you don't stop at 11, then at a 5 of, you have to notify and you get a vote to continue past 11.
Right.
But actually, you could continue on all night if you had the stamina to do it. There's no requirement to end it on the day that it starts. But I just had to say that because I didn't want other boards and committees to think that they had to.
Some things are better off.
That if they
not
wanted to
shared.
go past midnight, they couldn't. Anyhow.
Do we have any other selectmen's reports? Mr. Braga, you got anything
Well,
to
I
share?
actually have a lot, but I'm going to hold it until the next time.
I won't.
I have a lot.
You will, you
I
won't?
won't. I have 2 quick ones.
Sure.
I just want to report,
9:30, this is like the middle of the morning.
the Agricultural Commission did ask me to pass on that they are looking into the possibility of encouraging orchards throughout the town of Falmouth, and wanted to make sure that we had heard it first before that we heard it someplace else. And the second one was the CPC. We did have a preliminary report from the Cape Cod Commission on the Spring Bars Road project, and they have moved along quite efficiently with that. They will not have their final project report yet, but many of the questions that We, and the planning board and the town have been answered, and we'll be getting a formal report soon on that.
Okay, anything else? Well, again, just for everyone's information, the board does not meet next Monday. We'll meet 2 weeks from this evening. We'll be taking up our rest of our agendas on that particular night. Anything else? A motion to adjourn?
So move.
Motion and a second? All those in favor? Aye. Opposed? The ayes have it. Thank you.
Nestled in a classic New England setting amid 200-year-old elm trees and charming colonial homes, stately sea captains' homes, and charming Cape Cod salt boxes, Shoreway Acres is a graceful blend of Cape Cod's past and present. Shoreway Acres, proud sponsor of Falmouth Community Television.
Welcome to Falmouth. If you're a visitor, this is where surf and sun meet for fun. If you're a resident, this is where you'll find the businesses and the resources necessary to fill all of your needs. If you're a business person, this can be your home. Join with other men and women who work together to make this a sustainable economy year-round. Welcome to Falmouth, Cape Cod.